Hello and welcome to today's webinar. I'm so pleased that you could join us today for a chance to hear from ASEAN about the changes to immigration rules and what that might mean for you. When the Prime Minister spoke back in May about the proposed changes to the immigration system, I knew what a significant impact this could have on our profession. And as someone who trained in Kerala before moving to the UK, I knew that many of you would have questions about what it means for you and how it could affect you because I had the same questions. A quarter of all nurses on the NMC register are internationally educated, and we make such an important contribution to health and care services across the UK. And I want to reassure you that the ASEAN is here to support you. In the last 5 years alone, around 100,000 nurses from around the world have joined us here in the UK. But the number of new joiners who were trained outside the UK has also fallen by nearly a third in the most recent data we have. Added to that, the number of internationally educated nurses leaving the register has also increased by a third when compared to the same period last year. These are really worrying signs when we bring so much to the UK workforce. And recent government proposals pose a significant risk to the recruitment and retention of this critical part of our healthcare workforce. The ASEAN believes we need an immigration system that works for nursing staff and the people who rely on them. And we are also deeply concerned by the scale of racism faced by nursing staff recruited from outside the UK. Anna will talk a little later about some of the findings in our recent report, Unreciprocated Care. I really recommend everyone to read that report. But I want to reassure you that all of you here and all of our internationally educated colleagues that you are a valued member of UK workforce and ASEAN is here for you. We should be welcomed, not penalized, when we are so crucial to the health and wealth of the UK. I'd also like to remind you that ASEAN offers a personal immigration advice to its members. So if you're not already a member, please take the time to look at our membership offer on the ASEAN website and understand the benefits and savings you could make by signing up. We also have a discount sites. If you have any questions for our speakers, please do pop them in the chat at the end of the presentation, and we will have time to answer these at the end of the session. Now, I would like to introduce the first of our speakers, Sophia Barrett, Senior Immigration Advisor and Solicitor, who will talk through the immigration rule changes. Welcome, Sophia.
Thank you so much for that introduction, Bijoy. So yes, I'd like to first cover just some of the proposals that were initially raised under the white paper back in May. And the second part of my presentation will cover what has now been placed into law from the 22nd of July of this year. So if we can go to the first slide, my presentation. So I'll also cover some recommendations going forward in light of the post 22nd of July changes. Next slide, please. So the white paper was introduced by Vet Cooper in May of this year. And I will put a link to this white paper because it does cover quite a number of proposals that the Home Office are planning to introduce over the next year or two. But it's important to note, or important to mention, that the purpose of a white paper is not law, but it is an important document because it does outline the proposals for government policy going forward, and it gives affected people the chance just to possibly prepare for what may come in the near future. But whenever a white paper is produced, it is not yet law, but it does engender a lot of anxiety and apprehension when changes are proposed. Next slide. So I'm going to cover some of the key proposals that the white paper has outlined, particularly in how it relates to people on the health and care visa. The white paper does cover some other aspects, some other changes for people not in this category, but for the purposes of today's webinar, I'm just going to focus on the key proposals that affect many of our members. The main issue that hasn't yet been introduced at the bottom so far is the English language requirements for visa holders and their dependents. But I will cover the issues that I have outlined that was covered in the white paper back in May. Next slide. So paragraph 71 of the white paper essentially stated, and there were leading up to the white paper being produced, that from going forward, people sponsored in adult social care, that the skills requirement would be requirement for RQF level 6. So that's degree level, unless your role is registered at that level. So degree level role, you would not be you will not be eligible for a health and care visa. So that effectively reduced the number of the roles, or proposed number of roles that were eligible for sponsorship. But what the white paper did outline, that those who are already in the UK, who are sponsored in RQF roles registered at 3 to 5, so below level 6, there would be some transitional protection. So if you were already sponsored in a care role, for example, a role that is not registered at level 6 and above, you would continue to be eligible to remain in the UK and extend your visas. But what was important was that this would be kept under review. So next slide. So one of the quite positive aspects of the white paper was the government clearly had been listening to many of the concerns that RCN had raised in the years leading up to the publication of this white paper of exploitation and exploitative practices in the adult social care sphere, with regards to many workers fearing for their immigration status, because many employers were using the immigration status of particularly care workers as a sort of leverage, effectively, to control the people in their workforce who are being sponsored. So it's quite positive to see that several of the proposals in the white paper was that the government are planning to introduce measures to combat this and to perhaps prosecute and punish potentially exploitative employers. And also, as you can see from paragraph 176 of the white paper, to actually make it easier for workers to move from one sponsor to another without risking their immigration status. This is a proposal. We don't know how the government intends to carry this out, but it's something that is contained in the white paper. Next slide. And again, in terms of protection, also the exploitation of children, there is plans to introduce further legislation to protect children who could be subject to exploitation by employers. Next slide, please. So as highlighted earlier, one of the key changes, not yet law, but one of the proposals is to increase the skilled worker language requirements from level B1 to B2, but quite crucially, in terms of a change, is that this will also apply to adult dependents. So effectively spouses of skilled workers. So at the moment, for people who are applying to enter the UK as spouses of British citizens or people resident in the UK with indefinite leave to remain, they are subject to a language requirement at least level A1, which is not a requirement that workers' dependents are required to undertake. But this is a proposal that the government intends to put into legislation at a later date. It's not yet law, but it is a proposal. Next slide. So yeah, it's just to again to reiterate the commitment to what the government are sort of saying, it's integration within the UK, that individuals will need to increase their level of English ability. So next slide. So, and this is an issue that I know my colleague Anna in international policy is going to discuss in her presentation. But one of the quite alarming proposals was the intention to increase the current 5-year route to settlement from 5 years to 10 years. Even more alarmingly, potentially that this new change would be also applied to people who are already here. So if you entered the UK on a 5-year route to settlement, believing that you would stay on a 5-year route to settlement, what the proposals in the white paper outlined as possibly that you would also have to spend 10 years in the UK before you can apply for indefinite leave to remain. However, one of the proposals in the white paper was that potentially you could have that could be reduced. So you wouldn't have to spend 10 years. You could spend a reduced period in the UK, something between 5 and 10 years perhaps, if you can show you've earned that right to actually have that reduction from 10 years. Proposal, we don't know how this is going to work in practice. We do not know if it will apply to people who are already here or if it will just apply to new applicants entering the UK. Next slide, please. So I think this will be subject to a consultation by the Home Office. It's not been enacted into the rules as yet. The government actually wants to hear from people potentially affected by this potential change and will seek views from the public consultation. Next slide. And the same is going to apply for citizenship. So at the moment, once you've been granted indefinite leave to remain, The proposal is again an increased residence requirements before you can apply for citizenship, and again a potential reduction in that increase if again you can show you've earned that. So it's effectively you're showing that through your actions as a resident in the UK, there's a public good that you can show that you have provided to society. It's very general. There's no criteria in the white paper, and again, this is again subject to public consultation. And next slide. So here we come to the sort of meat and bones of the changes that have now been enacted into law. And what was made clear in the statement of changes in immigration rules that was published on the 1st of July was that what the crucial date would be the date that your certificate of sponsorship was assigned. So was published by the employer and given to the worker. So any worker who was issued with a certificate of sponsorship dated before the 22nd of July would continue under the existing rules, and anyone with a certificate of sponsorship dated from the 22nd of July onwards would be subject to the new rules. So effectively, if you were still outside of the UK and you wanted to enter the UK as a carer, you had to apply. You had to apply before the 22nd of July. Next slide, please. So the rules, and this is from, again, I'll put a link to the explanatory memorandum. So this memorandum accompanied the statement of changes that were published on the 1st of July, and it basically confirms that there is going to be a transitional period from July 2025 to July 2028. So if you were already here in the UK, working as a sponsored worker under the healthcare visa, your rights to remain in the UK remain. They will not change. So you can continue to extend your visas as you normally would. The essential change really is for people trying to apply to enter the UK from outside of the UK. The route has now been closed to non-UK residents. You cannot apply to work as a senior care assistant or care worker if you're outside the UK. That route is now closed. Next slide. So this is information that's currently on the RCN Immigration Advice webpage. So it just gives a summary that from the 22nd of July, if you are sponsored in the care role 6135 or senior care role 6136, you can continue to extend your visas. You can continue to work in the UK. That does not change. If you are working in the UK as a care assistant, but you're in another visa category, so for example, we have a lot of members who are on graduate visas, whose visas are about to end because they're only for 2 years. If they wanted to switch into the health and care visa category, they can still do so. They're still able to do that work, but they must have been working for their employer for a minimum of 3 months on the date that they apply to switch into that new category. Next slide. So the quite an important point here is the ability for people who are working as care workers to remain in the UK with their families. So again, this is where transitional protections apply. So if you were in the UK working as a care assistant and you still have the right to have your family members with you in the UK or apply to join you in the UK, that remains unchanged only if you were sponsored as a care worker prior to the main rule change regarding dependents that took place in March, the 11th of March last year. So if you have been a care worker, a sponsored care worker in the UK with a health and care visa since 2022, 2023, and perhaps your family members haven't yet applied to join you, you can still apply for them to join you in the UK. And I'd probably advise that you should do so if they're not already here. But if you were first sponsored after the 11th of March 2024, when that right to have your family members join you ended, that continues. There's no change with that. You still cannot have your family members with you. And if you are, again, if you're on a graduate visa, for example, and you successfully manage to switch from a graduate visa into an RQF level 3 through to 5, you will not be able to have your family members with you. So if they're with you now as dependents on your graduate visa, they will not be able to stay with you if you switch into the health and care visa category. Next slide, please. The salary threshold for health and care workers, that increased in April of this year, on the 9th of April. There are no transitional protections here. Any new certificate of sponsorship issued after the 9th of April 2025 must show that the worker is earning £12.82 per hour and a minimum of £25,000 a year. There's no transitional protections for this. This is the date stamp, 9th of April. Any certificate of sponsorship issued after that time has to adhere to the salary threshold you see on the screen. Next slide, please. So going forward, recommendations, and this is it's often a really difficult thing for me to advise people because I appreciate the costs involved in applying for indefinite leave to remain and for citizenship. But simply speaking, if you are eligible to apply for indefinite leave to remain, if your family members are eligible to apply for indefinite leave to remain, I would advise to apply as soon as you can. Although we have transitional protections for care workers, the rules have stated that this is under review. So the Home Office could at some point provide another set of changes to the immigration rules that limits the ability for people who are already working in non-degree level roles. So that the advice is, please apply for ILR if you're able to. Please check back on the RCN Immigration Advice website for any updates. And also where you are looking for employment, I always guide people to the NHS employer website, to the ethical recruiter list, because there are lots of unscrupulous recruiters out there who will promise for a fee that they can guarantee you a certificate of sponsorship and a sponsored role. Refer to the NHS employer website, to the ethical recruiter list, so that you potentially will not be exploited or scammed into handing over your money for a role that potentially doesn't exist. That's the end of my presentation. I'll leave you now to my colleague Anna.
Thank you, Sophia. And my next section will be quite quick. I'm just wanting to run through how the RCN is responding to some of these proposals, particularly looking at indefinite leave to remain. Next slide. Perfect. Thank you. So, I mean, Sophia has already gone through the details of this, but just as a recap, the white paper proposed that the qualifying time for indefinite leave to remain could possibly be extended from 5 years to 10 years. As Sophia said, we're really not sure what that means for this moment. The white paper isn't binding legislation, it just shows government's intention for a policy, and they will be consulting on this later in the autumn. Government has suggested that there may be concessions for what they've called highly skilled, high contributing individuals. And in this, nurses were named as one of the examples of that. My concern is that there hasn't been enough detail on what this might mean. So it might mean that nurses don't have to wait 10 years, but possibly they'll be still waiting more than 5 years. I'm also not sure what this could mean for nursing support worker roles. And as Sophia's correctly said, we really don't know what this means for people that are already here. And yeah, as I've said, government is looking to consult on these proposals in the autumn. If I could have the next slide, please. But yeah, so essentially the RCN is responding to these proposals. I should highlight that the RCN has got a history of responding very strongly to immigration proposals that we know are harming our members. We published a report earlier this year, which actually showed that 42% of IENs are thinking about leaving the UK. And we know that a lot of that is because of really restrictive immigration rules. People were citing in that challenges already on, the high costs of getting ILR, as well as issues around no recourse to public funds and family visas. So I think our real concern is that any more restrictions on indefinite leave to remain will just make the UK a really unattractive place for people to live and work. Some of the ways that we're planning to challenge this. So at the moment, we have a survey out for all of our internationally educated members. You can also be a non-member and respond to that. And we really want to gather people's views on indefinite leave to remain so we can make the strongest case possible to government on how damaging it would be to increase the time limit to 10 years. We'll be responding to government's consultation in autumn and engaging in any kind of stakeholder discussions around that and working with partner organisations as well. Next slide, please. And this is a link to our survey. I'll also post the link in the chat, but it is currently live. It will run until next Tuesday, the 26th of August. So I would just encourage you, if you haven't done so already, please do respond so we can make sure to capture all of your views. There are also some specific questions in there for nursing support worker colleagues around what the changes might mean for them in terms of not being able to bring dependents over. Obviously, this is for people coming in post the 22nd of July, but we still want to capture those views. And I will hand back to Claire Bejoy. I'm actually not sure, sorry.
Brilliant, that's
we'll
fine, Anna.
Questions.
I'm going to run through the questions. We've got some in the Q&A and we've also got some in the chat. So I'll run through the Q&A questions first. So firstly, I think this one's probably for Sophia. Edmund has asked, are nurses not classified as degree level professionals as it reflects on QRF6? Sophia, you're on mute.
Sorry about that. Yeah, no, nurses are classed as an RQF level 6 role, so it's a degree level role. So those roles referred to as roles 3 to 5 are essentially adult social care roles, care worker roles, and that is the particular category that has really been under attack, I would say, over the last couple of years. There has been this government, as well as the previous government, to reduce the numbers of care workers and their dependents entering the UK. So that it's that specific role.
Thanks, Sophia. And Regina has asked, she says she's on a certificate of sponsorship 6135, and that was assigned in January this year. She's working as a registered nursing associate. She had her PIN in May, but she's still working as a carer. She wants to know whether, with the new regulations, does she have to switch employers before 2028?
No, because again, if you're going to switch to work as a registered nurse, I'm assuming, so you obtain a certificate of sponsorship to work as a nurse, that wouldn't affect you because nursing is a degree level role. So the main changes are those roles that are classified as non-degree level roles.
Thank you. And then another question, somebody who has indefinite leave to remain, but their dependents have to stay, and so they've put till 2006, but I presume that's 2026, and that's the date that their certificate of sponsorship ends. They want to know, how do they extend their visa, and will they be able to apply for an extension under the skilled worker route, or do they have to change to the family route?
No. So once you enter the UK as a skilled worker dependent, you continue extending as a skilled worker dependent. So even if the main applicant has since obtained indefinite leave to remain, so long as when you first entered the UK as a skilled worker dependent, you stay in that category. You don't move to another category, because if you do that, your residence clock effectively restarts to zero. So all the time that you've already spent in the UK as a health and care dependent is just erased. So you stay. So for example, a skilled worker dependent partner will stay in that category for 5 years and then apply for indefinite leave to remain, even if their main applicant spouse has since obtained ILR. They are still treated as a dependent of a skilled worker.
Thanks, Sophia. And then there's a question from Sangeeta, who came to the UK in October 2021. She completes 5 years next year in 2026. Her certificate of sponsorship ends in October 2026. Will I be able to apply for permanent residence, or do I need to wait for 10 years? If I have to wait for 10 years, will my trust sponsor me and extend my visa?
Well, the rules are still 5 years. That nothing's changed. There's been no announcement, so you're still on the 5 years route until the rules say otherwise. So for now, assume that you are still on the 5-year route to settlements. On the date that you apply for indefinite leave to remain, you must have spent 5 years in the UK. The earliest you can apply is 28 days before that 5-year anniversary, and not before. So for now, you're still on the 5 years route. Nothing has changed as yet.
Thank you. And then a question from John. He says, is it going to affect my job role? He's currently on a B6, but not at degree level. So will they effectively demote his job?
So is working as a carer, as a B6?
That could be band 6.
Band 6, sorry. So band 6 as a what role? What's his role as a band 6? I'm assuming as a registered nurse, I'm assuming.
He says not at degree level.
I would need more information. I'm not clear.
Yeah, John, do you want to
their role?
John, just
what's your actual job role?
John, if you just want to pop a little bit more information into the chat, and then we can pick that question up at the end. And then Elizabeth says that she came to work in the UK in March 2023. Is the permanent residence requirement 5 years in that situation?
Well, it's still 5 years as of today. It's still 5 years. It's a proposal to change it from 5 years to 10. It's not law. It's still in the white paper as a proposal. It's not yet law. So until it's law, you just need to assume that it's 5 years. And as I mentioned, going forward, the moment you are eligible to apply, you should apply. I mean, these changes may take place next year, the year after. We simply do not know. And that's really difficult because I can't give any solid advice. But for now, you just have to assume you are still on the 5 years route and you apply when you reach that 5 years point.
Thank you.
Yeah.
Then,
Sorry, I was just going to say, no, just reiterating what Sophia said, we just don't know what it will look like. So I think all we can commit to is just making members aware as soon as we know, we can publicise that widely. Hopefully we'll get some more information from government later this year, but it could be later than that. They haven't committed to a timeline, which we know is really frustrating for people.
And also, again, responding to the survey, Anna. Okay, so Mohammed has asked, what happens if one came in with a diploma certificate and registered with the NMC as a registered nurse? Will that person be able to renew their visa with their sponsor if they don't have a degree certificate?
No, I mean, it's just how the role is classified. So if you're registered nurse, you're on the NMC role, you're eligible to apply for a certificate of sponsorship to register to work as a nurse. I mean, that as long as you have been accepted by the NMC, you've met all the NMC requirements, you are on the roll, you have your PIN, you are ready to work as or apply for work as a nurse and obtain a certificate of sponsorship. That's the criteria. It's just how the law classifies these roles. They call it degree level. So you just essentially have to meet the requirements to register as a nurse with the NMC.
Thanks, Sophia. I think you may have answered this question, but it's about switching employers, getting a new certificate of sponsorship. Has that got anything to do with an application for indefinite leave to remain? They've been here since 2023 and they're getting into new employment by the end of this year. Does this mean I will not be able to apply for indefinite leave to remain by, it says 2008, but I imagine it's 2028?
If I'm understanding you correctly, then, or the question correctly, is whether or not changing an employer affects your ability to apply for ILR. Changing an employer doesn't affect your ability to apply for ILR. You just have to ensure that you follow the correct procedure when you change employer. So when you're leaving one employer to go to another, you need to obtain a certificate of sponsorship from that potential new employer. You go through the process of going online, completing the correct form, waiting for approval. So you can't start working for that new employer until your application has been approved, and then you start working for that new employer. So as long as you've completed the correct procedure, you can your continuous residence in the UK, that chain of residence is not broken. You can still obtain indefinite leave to remain.
Thanks, Sophia. There's a very similar question from Chika, but Chika, if we haven't answered your question, then if you can just let us know in the chat, but I'm going to assume that's a similar type of question. Okay, Josephine has said, is there a law that a nurse under skilled worker visa will be restricted from coming back to the UK when one travels to one's country?
I've not heard of that. That's not something I've heard of. I mean, so long as you've obtained the absence from work, you have authorized absence from work, so via annual leave, and when you return to the UK, you still have your sort of currency of leave. So if your visa expires in January of next year and you want to go on holiday, that's absolutely fine, as long as you return when you're supposed to return back to work from your absence from work for authorized leave, and you return to the UK whilst your visa is still intact. but there is nothing to say that you can't apply, you can't leave the UK. That obviously there are restrictions as to how long you leave, you're outside of the UK for. So there's a 180 days rule, that if you're outside of the UK for more than 180 days in any 12-month period, that could affect your ILR ability, but that's a standard part of the immigration rules. There's nothing there really to stop you from visiting your home country at all. But you just have to just make sure that that's authorised leave. You're absent from leave through authorised leave from work.
Thanks, Sophia. Question from Joy. Can a healthcare support worker who's just got their certificate of sponsorship cover the spouse and child?
Not if this is the first time you've been issued with a certificate of sponsorship. So if you've been here since, or sponsored, a bit more specifically, if you've been a sponsored care assistant in the UK prior to March the 11th, 2024, you can still have your family members with you in the UK. But if you didn't obtain sponsorship to work as a carer until after the 11th of March, then no, you will not be able to have your dependents with you.
Thank you. And then Janet asks, for the 3-month employer requirement, if you work in the NHS and move to another trust, do you have to work 3 months for the new trust before you're eligible for the certificate of sponsorship?
So it depends. So it's really essentially for people who are switching categories, really. So if you're currently working as a carer for a trust, as a student, you're on a student visa or on a graduate visa, for example, and you want to switch from that category into the health and care visa category, you can apply with a certificate of sponsorship from an employer that you've been working with for 3 months. So if you've just started working for an employer, then no. If you're switching into the health and care visa category.
Thanks, Sophia. And then there's a question that says, I'm an NHS nurse. I came to the UK in January 2021, and then husband joined me in December 2021. Can we still apply for indefinite leave to remain together, or does he have to wait months after to apply for indefinite leave to remain?
So he'll have to apply once he's been in that category for 5 years. So he's been as a skilled worker dependent for 5 years. So if when his visa's about to expire, if he hasn't yet reached that 5-year period, so he possibly could be 6 months away from that, he's going to have to apply to extend his visa. The earliest you can apply is 28 days before you reach that 5-year anniversary, not before. So if you're just short, you're going to have to apply to extend your visa or he will have to extend his visa as a skilled worker dependent.
Thank you. And then a question from Mary. She's working in the NHS and she's band 5 since 2022 in November. And she wants to know if bringing her husband under the new regulations need him to attain any extra requirements than the past. And if so, what would those be?
No, there's no extra requirements other than showing that you are married as claimed, or if it's an unmarried partner relationship, you'd need to show that you had been cohabiting for a period of 2 years. But those are the current regulations. There's nothing extra. But as mentioned in my presentation, skilled worker spouses, for example, will need to show that they meet at least A1 English language requirements, but that's not currently law. So there's nothing new as such now.
Thanks, Sophia. And then there's one for Anna. The current certificate of sponsorship system is clearly and visibly enabling modern slavery by tethering a migrant worker's right to work and residency to a single employer. It creates an extreme power imbalance. Workers are trapped in a precarious position, often in debt due to illegal recruitment fees, and are afraid to report the abuse for fear of having their licence revoked, which would result in deportation. The systemic issue is a significant driver in exploitation. Can we expect any change in this policy?
Thank you. Yeah, so this is an issue that we're really aware of. We're aware that lots of IENs, particularly in the care sector and the independent sector, are facing, really horrific instances of exploitation. And it is primarily linked to the fact that they're very dependent on their employer for sponsorship. And we know that some employers are sort of wielding that power. With threats of deportation. It's something that we've raised. We are calling for a review into the certificate of sponsorship system. We're calling for an investigation into the exploitation. We're trying to get it on government's agenda. It's the kind of change I personally would have liked to have seen in this white paper. I think that would have been a really important thing for them to have focused on, but unfortunately it hasn't. But it is conversations that we're raising with government. Claire, we're not hearing you if you're speaking.
Hear me now? Excellent. So this is a question for Sophia. How will the dependent get the sponsorship to continue on the dependent visa route since they are not the main applicant?
Dependents do not need to be sponsored. Obviously, it is just the main applicant. That's always been the case. So if the main applicant is eligible to have their dependents with them, then they would simply apply and supply the relevant supporting documentation. So whether they are able to apply from abroad to enter the UK, or they're applying to extend their current visas, but only the main applicant requires sponsorship. A dependent doesn't require any sponsorship at all. They just need to show their relationship to whether it's a spousal or parental relationship to the main applicant. I hope I've answered that.
I think I might have lost you. I'm sorry.
Can you hear me now?
Yeah.
Yes.
Excellent. Sorry, I don't know. I think that must be my reception. This question is, I think, quite an important one. I think you may have covered it off, Sophia, in the initial presentation, but it has been coming up quite a lot. A friend has been working as a carer for 2 years and has recently lost their sponsorship and their job. How much time do they have to find another sponsor before expiring visa and losing their leave to remain?
There is, unhelpfully, there is no set timescale for the Home Office to contact a worker in that situation. So when an employee, when a sponsored worker loses their job, whether it's through dismissal or redundancy, the employer has to let the Home Office know within 10 days of that worker leaving, to let the Home Office know that that person's sponsorship has ended. We've got lots of information, and I'll put a link in the chat. We've got FAQ to what to do in these situations. The advice is always to really aim to find a new sponsor usually within 8 to 10 weeks of leaving, because after that period, and we're finding an increasing number of members coming to us with curtailment letters. So if your visa is due to expire, you've got more than 60 days left on your visa, the Home Office will contact you at some point to let you know that that visa has now been shortened down to 60 days. If you've got a year left, it will be shortened to 60 days. There's no set time scale that we can advise you. There's nothing in the rules that says the Home Office has to inform you by letter. You simply just have to I say simply, you have to obtain a new sponsor as soon as you can. The moment you put in an application, that will stop any enforcement or any curtailment or shortening action by the Home Office. You just simply have to get an application in to the Home Office. You don't have to start the new job. You just have to get that application in as soon as you can. Otherwise, the Home Office will contact you if you have more than 60 days left on your visa to inform you that your visa will be shortened to 60 days.
Thanks, Sophia. And then another question about being sponsored as a healthcare assistant and the pay not being 25,000. If I need to renew my visa by 2027, NHS pay hasn't increased yet. Will my visa be extended by my trust regardless?
Your trust, I mean, if your trust gives you a certificate of sponsorship and it shows that you're not going to be paid at the salary threshold, then your application will be refused. It's a mandatory requirement. There's no sort of leeway for an employer to ask the Home Office to exercise some discretion. It's a mandatory requirement. I know it's a difficult situation.
Yeah, I was just going to add to that. We know it's a really challenging situation. It is, again, something that we're challenging. RCN President Bajoy wrote to the Minister for Migration a few weeks ago, really showing what an impact this is having. I think there's a bit of a misunderstanding at the Home Office that not many people are impacted by that, but we are gathering up member cases so we can show them that we know that lots of people are being impacted by this rule.
Thanks, Anna. And then a question from Mercy. I'm on a partner visa and need to change my surname to my husband's surname. Only been 2 years in the UK. They're both nurses. Mercy came as a partner and her husband is on a skilled worker visa. Is she going to be affected?
I mean, change of name issues. I mean, the Home Office, when you apply, they rely on the name that's given in your passport. So if you're planning to continue extending your visa and you've changed your name, you're going to have to go to your country's sort of embassy to get your passport, the name changed in your passport, because that's what the Home Office goes on in terms of verifying who you are.
Okay, thank you. There's still lots of questions about sort of band 3, but I think we've probably covered that off, unless there's anything else you want to add, Anna. Really about what the RCN's doing, but we've written lots of letters and I came to the UK on the 1st of October 2020, but my visa was granted on the 28th of August 2020. Will I be eligible to apply for indefinite leave to remain now?
Yes, I mean, so long as you've met the requirements over the last 5 years, you resided in the UK on a continuous lawful basis with your health and care visa, there should be no issue with you. You should be eligible to apply for indefinite leave to remain so long as you meet all the other criteria as well, ensuring that you've not been out of the UK for more than 180 days, you meet the language requirements. So it's just a matter of, can you show the date that you apply that you've been in the UK for 5 years on a continuous basis with your health and care visa, and you meet all the other requirements.
Sibin mentions that there's a debate on the 8th of September in Parliament. Can we expect a positive response?
We're aware of it, and I think the RCN will probably brief into it. So I don't know what will come of it yet, but we are looking at every opportunity we can to influence on it.
Thanks, Anna. Just going to see if there's any new questions about different topics. We'll just take one more.
Claire, I can see there's been a few questions around registered nurses bringing dependents, and I don't know if it's worth Sophia clarifying that point for members. Just that I think there might be some confusion that registered nurses are limited to bring their dependents.
Yeah, I'll just give an example. Our nurses still allowed to bring in dependents till the end of this year.
There's no change for registered nurses. The only category in the whole of the skilled worker regime who are limited into having their family members with them are carers. So people who are sponsored as carers who were first sponsored after the 11th of March 2024. It's literally that group of people who are affected. So carers who were first sponsored before that date can still bring their family members, but anyone who obtained their first were issued a certificate of sponsorship dated after the 11th of March 2024 to be sponsored to work as carers cannot bring their family members into the UK.
Thanks, Sophia. And then probably just one last one. How long does it take for a visa to be extended after application?
Officially, I was asked this about a week ago when I went onto the Home Office's website. They do have and I'll put a link. It was saying 3 weeks for health and care visa applications to be processed. That's on average. I'll put a link. But 3 weeks on average.
Excellent. Thank you very much. Well, there's still a few questions in the chat, but what I would say is that the link to the immigration pages that we sort of dropped in the chat along the way will provide a lot of information, Sophia, in addition to what we've talked about today. And if you still have some questions, then do ring RCN Advice Centre and they will be able to make a referral to the Immigration Service. I'm going to pass you back to Bajoy, who's going to close for us. Thank you, Sophia and Anna.
Pleasure.
Hi. So, as you all seen, we are really concerned about the impact of these changes, and we are working behind the scene day and night to guide the government in the right direction by influencing this policy and decision making. And stories from the member side to the government and the ministers. So you've seen this as a powerful, remarkable example how we can, working together collectively, influence the things that affects us. So before we closing, I just want to give you 5 reasons why you should join Royal College of Nursing. I often describe we embrace with both hands the professional development from with one hand, and with the other hand, the support that you need. So your own development and the workplace support. So we've got loads of support in terms of professional development and the learning resources. We've got the largest nursing library in the world, and workplace support when you're in need of help and support and workplace guidance. We've got that help. You can see the link on the slide. And we've got one of the largest legal in-house teams for any UK trade union. So if you have a legal question to ask, just give us a call. Or you've got a link on our website where you can ask questions as well. So we've got immigrations advice, welfare guidance, and different career coachings such as CV writing, preparing for interviews and career planning, telephone counseling, and we've got peer support for members with disability, and we've got all these services available to us. And please do log into our website. Please do engage to our surveys. For example, our current immigration survey, and your stories and your perspective add power to us when we negotiate with our with the government. And if more people engage with our surveys, more power that we have collectively. And ASEAN's power is ASEAN's members. So with all the engagement that we had tonight, I'm more confident that we will be going in the right direction, and some of the pressing needs that you express tonight, we will be able to influence more efficiently with your support. And thank you everyone who participated, and thank you all the panelists who answered patiently all the questions, and thank you all the members, and we will come back with more of this useful sessions on different topics. So please look at all the emails that we send. So these are important information that's coming through your email. So please do engage and join forces with us. Thank you.